SJC-11476, Milton C. Weiler, Jr. v. Portfolioscope, Inc., et al.
May it please the court. My name is Curtis Funder. I represent the plaintiff appellee, Milton Weiler. I would like to reserve 2 minutes for rebuttal, please. Mr. Weiler prevailed in this case after a bench trial, no jury, in the Superior Court before Judge Margaret Hinkle, who awarded damages to Mr. Weiler under a number of claims. I think there were 7 claims. But including for breach of contract and unfair and deceptive conduct by the defendants, all 3 defendants, in violation of the actual fraud provisions of the Massachusetts Uniform Fraudulent Transfer Act, as well as Chapter 93A, Section 11, and imposed double damages. I would like to argue 4 points today. First, the defendants waived their trade or commerce argument under Chapter 93A because they failed to raise it in the trial court or the appeals court. They never briefed it in either court. It was never argued in the appeals court at all. And in response to the arguments made on this point in the defendant's reply brief, I'd like to point out that the issue is not jurisdictional. It is an element of the Chapter 93A, Section 11 proof. And so, therefore, it is waivable. And I will explain more. The second, if this court reaches the Chapter 93A issue on the merits, the appeals court was wrong because Weiler was an independent contractor vis-a-vis Portfolioscope and the other defendants, and he was never employed by defendant Kimberlin. There was never any employment relationship between Weiler and Kimberlin, and they were not in that kind of a relationship, and so it was not an intra-corporate dispute. And Kimberlin was never a shareholder, officer, director, or employee of the defendant corporation, Portfolioscope. He was not a member of Portfolioscope. Third, as the trial court ruled,
Weiler was the former CEO, had stock options, and what this whole transaction was about was the purchase and sale of stock options by the company, right?
No, Your Honor.
Isn't this what this was about?
Your Honor, no. The 5% agreement that is at issue here, which I'll get into more, had 2 different parts. In the first part, it was the sale of the stock options, and that was done in February 2002, February 13, 2002.
So you're saying
it was not until later, pardon me?
You're saying the amendment is really something separate.
The amendment is something separate. The amendment took place, the amendment was later in October 2002 and was a pure contingent fee arrangement for future services working on the claims against iFlex by Mr. Weiler, which resulted in the $10 million recovery. And that was, all the stock options had been sold already in February. And Mr. Weiler had already resigned as an officer and employee of the company on May 17, 2002. Later, he started working under consulting contracts, working on this claim.
I didn't mean to distract you. Your third point, I'm sorry.
Thank you, Your Honor. Third, as the trial judge noted, ruled, Portfolioscope's payment of $515,000 of the iFlex settlement proceeds to defendant Weiler, instead of paying Weiler, was illegal and in bad faith, both as a breach of the covenant of good faith and fair dealing under the contract with Portfolioscope, but also because it was done with actual intent to defraud Weiler in violation of the Fraudulent Transfer Act. And that's as to all the defendants, the individuals, Kimberlin and Weiler. as well as Portfolioscope. And fourth, as the trial
When
court,
you say actual intent, you mean actual malice?
the language is actual intent to hinder, delay, or defraud.
okay.
It is sometimes referred to as the actual fraud prong of the two prongs as opposed to the constructive prong. Constructive fraud.
Uniform.
But it's different than common law fraud, Your Honor. It doesn't mean that from day one it was known that it was a lie, but it's actual intent to defraud is what I'm referring to.
But I think the question goes to, you're not, the other argument is actual malice in terms of the intentional interference.
Oh, yes, yes. On the tortious interference claim, the judgment against Mr. Kimberlin, there was no argument in the lower court or the appeals court, no argument until we got to this court by the defendants that actual malice was required on the part of Mr. Kimberlin to sustain Mr. Weiler's judgment on tortious interference. And I would like to, if we have time, I can be happy to address that one too.
Since we're on point 3, the judge found that KKPLP, quote, allegedly, unquote, gave Portfolioscope a $500,000 credit. And then later at page 20, she found that Portfolioscope received no value in exchange for $515,000 transfer to Mr. Wellaghan. Your brother says the evidence is clear that that money was credited to the debt. Do you agree that the evidence was clear that KKP credited that $515,000 against the amount owed by Portfolioscope?
No. And if I may explain, no, because whatever they put down in their accounting books at KKP, which, by the way, KKP is a bit of a misnomer. It's Kevin Kimberlin Partners Limited Partnership. And in the defendant's brief, they like to just start off referring to it as KKP, but it's really Mr. Kimberlin. So whether they accounted for it later in their books, whatever they did, we don't have any control over. But the judge heard testimony. What Mr. Wellaghan and Mr. Kimberlin testified about what the payment to Wellaghan was for. And the trial court, with no jury, determined that she discredited that testimony. Specifically, Mr. Wellaghan said that it was for, first he said it was a generous tip. Then, that's in his deposition testimony that was admitted as part of the trial testimony in the jury waived case. Secondly, he said, well, it was for work I had not been compensated for a long, long time in doing a number of projects on behalf of Spencer Trask, Mr. Kimberlin's, the company that Mr. Kimberlin was a chairman of, and perhaps other Kimberlin-related entities. And he was shown to be less than forthright, and the judge discredited that, partly because she found that, as we proved, that Mr. Wellaghan had given a prior deposition where he had said that he had been receiving a $9,000 per month retainer from Spencer Trask for various assignments by Mr. Kimberlin on behalf of Spencer Trask and its complex web of entities, as they described it. Mr. Kimberlin was unable to explain the layout of the whole.
Your brother says in his brief, and probably will say again, it doesn't matter if there was truly a debit of if Portfolioscope truly debited $515,000, it doesn't matter what Wellaghan, what KKP used it for. KKP could say, send it to my favorite charity and I'll take it off of your debt.
Your Honor, if it was KKP's money, maybe there'd be something to that, but this is a very crucial point. The payment to Wellaghan was made, the trial court found, the payment was by Portfolioscope to Wellaghan. The money went directly from Portfolioscope's account into a new account that Wellaghan set up in his wife's name.
But couldn't you, on that point though, couldn't you conceive of, if the secured creditor says, I want you to pay $515,000, look, you owe me $1 million, and I want you to pay $515,000 to his wife, you could do that, right?
I think not in this case, Your Honor, because the money it did not go to KKP. First of all, the payment to Wellaghan went right to Wellaghan. But secondly, the money that even was supposedly for KKP didn't go to KKP. It went to Spencer Trask. At the direction of Kimberlin, Kimberlin directed Wheelahan to send all the money to me, and it went to Spencer Trask. There was no document in this case showing that the money ever went from Spencer Trask to KKP. There was testimony by Kimberlin that it was for the benefit of KKP. Interestingly, for months after we sued, the defendants were unable to identify who the supposed secured creditor was. They came to court hearing after court hearing. They filed interrogatory answers under oath saying, we are unable to tell you who the secured creditor is, and we can't find the records. And finally, that was on July 31st, 2009, and that's in the record at 1362 to 1363. So that's an example that I think, I get the sense that this whole idea that it was to KKP and that KKP was this fiction, it's a fiction, Your Honor, that KKP was paying Wheelahan that was convenient to come up with later.
But the fact that there was a debt was not fictional. I mean, there was money owed. The bank that had originally loaned the $4 million or whatever was paid off by KKP, right? And then KKP extended further credit. Am I wrong about that?
No, you're not wrong, Your Honor.
So there was $7.7 million or some amount, maybe more than that was owed by Portfolio to whoever the secured creditor was.
Your Honor, yes, but the secured creditor here was not some third party like Wells Fargo Bank or something like that. It was Mr. Kimberlin. It was all insiders.
I appreciate that, but I think following up on that, if it were a third party, is there any question but that they could have taken all of the settlement proceeds?
Yeah, yes.
They could have.
No, they couldn't. In other words, when you say take all the settlement
I mean,
proceeds, are you asking aside from Wheelahan?
Yeah, I'm talking, not Wheelahan, I'm just talking about, isn't there a question here about whether or not the payment for the, under the 5% agreement could be made, it was supposed to go to the lawyers first, and he says, well, then it was supposed to go to me, and then it shouldn't go to any secured creditor. And my understanding is that your argument is that somehow it couldn't go to KKP as a secured creditor, but what is the situation if it had been a third party who was a secured creditor? Couldn't they have trumped the 5% agreement and said, well, we have it, we have a security, we have a perfected interest?
For two reasons, I'd say no. First, the trial court found that all the transfers were fraudulent transfers with actual intent to defraud in violation of the Fraudulent Transfer Act, as well as 93A, and that the UCC didn't trump everything here. But in addition, in this case, the money, the payment to Wheelahan was not a payment by the so-called secured creditor, which was an insider, Mr. Controlled, and for the benefit of Mr. Kimberlin. Also, Wheelahan was an insider as the CEO of Portfolioscope, so it was of, by, and for the insiders. They concealed the payments. These are all badges of fraud. They rendered the company insolvent and unable to pay Weiler. Now, they challenged that in their brief, but...
insolvent, except there was this $1.2 some million that was set aside, right?
That was under a court order
Right.
set aside for Mr. Hunt's Mr. Hunt's claim against Portfolioscope.
So that was still an asset of Portfolioscope, at least theoretically.
Well, I think that money went to Spencer Trask. All these transfers went to Spencer Trask, and Portfolioscope didn't have it anymore. So it went from Spencer Trask into the escrow account, perhaps, but not from Portfolioscope.
Let me ask one question more, if I might. The October 2002 amendment, who negotiated that amendment on behalf of Portfolioscope?
Mr. Kimberlin.
Is that clear in the record?
Absolutely.
That's all I
He
wanted.
incentivized Mr. Weiler to go out and do 6 years of work, as it turned out, to pursue this claim without disclosing to Mr. Weiler. He's the very same person, the insider, so-called secured creditor, is sending Weiler out to do this and then snaps all the money, siphons off all the money when the money comes in, leaving him with nothing. And never told him that it was going to a secured creditor until months into the litigation.
Thank you, counsel. You've reserved some time.
Good morning. May it please the court. I'm Andrew Nathanson, and although I'm arguing second, I'm representing the appellants, Portfolioscope, Inc., Kevin Kimberlin, and Joseph Wheelahan. I think you've got it. It's the money trail that makes the difference here. It's who paid who and on whose account. And I'd like to clarify a few points. With respect to the payments to Mr. Wheelahan, which clearly the trial court thought was important, it was the only basis that the trial court cited for finding on Mr. Weiler's behalf with respect to the breach of the implied covenant and the interference claims. There's nothing fictional or unusual, and certainly nothing nefarious about A paying B on C's behalf. As we pointed out in our brief, account debtors do that every day. And it doesn't matter who the money goes from physically and to whom.
But it may matter if it's an after-the-fact explanation. As I understood, it wasn't, this was a telephone call from Mr. Kimberlin to Mr. Wheelahan. It wasn't a, KKP is the secured creditor, and KKP directs you to pay to your wife. It was a very informal thing that got defined as you now define it after the fact.
Well, it was informal, but again, I don't know that informality is necessarily the test.
Matters who's directing and on whose behalf, and that isn't clear to me that anybody knew that at the time.
Well, Mr. Wheelahan testified that if he had not received permission, Mr. Wheelahan, who was acting as the CEO of Portfolioscope, so he was making the payments on behalf of Portfolioscope. He testified that if he had not received permission to direct the payments to himself, as it happened, although it could have been
From whom?
somebody else, from Kevin Kimberlin,
Right.
who was the person in control of the secured creditor to whom Portfolioscope
But was
owed
it
the
in
money.
that, I mean, but in what capacity was Kevin Kimberlin directing him? That's what I'm saying. From Judge Hinkle's finding, all I think she said was that it was by some phone call. I mean, I just don't know that you're right. If you look at, if you sort of think of this theoretically, there can be no issue, but it's just not clear on the ground whether it played out that way.
Well, I mean, the only testimony that we have with respect to that is Mr. Wheelahan's testimony that he asked Mr. Kimberlin for permission to direct the money to himself rather than to KKP. He testified unequivocally that if he had not received that permission, he would have handed the money over to KKP. And we also have Mr. Kimberlin's testimony on behalf of KKP that KKP credited every payment, every dollar that got paid either to KKP or to Mr. Wheelahan against Portfolio's debt to KKP.
Now, what do we do with the judge's finding at page 20 that Portfolioscope received no value in exchange for the $515,000 transfer?
As I read that sentence, Your Honor, what the judge is referring to is, she's saying, contrary to the defendant's assertion that Wheelahan was owed payment for services rendered, Portfolioscope received no value in exchange for those transfers. As I read that, what the judge is saying is that there's no evidence that Wheelahan was owed payment by Portfolioscope for services rendered. Therefore, when Portfolioscope paid Wheelahan, Portfolioscope wasn't receiving value from Wheelahan. But that's not the argument. The argument is Portfolioscope was receiving value from KKP.
Okay, but that's not what she said that KKP allegedly gave him a credit. So
She
what do
never
we
made
do?
a finding one way or the other about whether the credit was given.
And what is the evidence that there was a credit?
Mr. Kimberlin's testimony. Mr.
And
Kimberlin's
do we have any
testimony
reason to believe
was
that was credited by the judge?
she neither credited it nor discredited it.
So doesn't it matter? I mean, if there was no credit given, would your argument survive?
If the judge had made an explicit finding that there was no credit given, we would have to argue that finding was clearly erroneous, which I think there is room to do because there is no countervailing testimony. But the judge noted it. She noted the testimony, but she made no finding one way or the other. She did not say, I discredit Mr. Kimberlin's testimony that I gave a $7 million credit for $7 million in payment.
But in the absence of a credit for the Wheelahan payment, you lose, don't you? I mean, if that survives as a fact finding.
Yes, if there was no credit given, that's absolutely correct.
You lose on what?
On the good faith and fair dealing?
It would be the good faith and fair dealing, yes.
Okay.
What do you say, I know you say something, I'm just forgetting. Mr. Funder argues, in any event, Judge Hinkle found actual intent, all these transactions had an actual intent to defraud. Would that answer this? If that's so, does that supply an answer to whether you can claim this is just a secured transaction playing out?
No, because the judge made a finding that there was actual intent to defraud within, with respect to the specific definition of intent to defraud under UFTA. And as we argued in our brief, she made an erroneous finding of actual intent, precisely because these were payments, and again, for the moment, we'll assume that the payments to Mr. Wheelahan were for credit. These were payments to KKP. KKP was a legitimate secured creditor. KKP had loaned the company between $7 and $8 million, and these payments were made to satisfy that legitimate debt. And under UFTA, if you have a legitimate payment to a legitimate debtor, and there is no secret trust, there's no hidden benefit to the debtor in the payment, then it is not a fraudulent transfer. And that's exactly the situation here. It was a payment to a legitimate debtor in satisfaction of a legitimate debt, and there's absolutely no hint of a hidden trust for Portfolioscope's benefit.
Was there any evidence that the payments made to that secured creditor were either consistent or inconsistent with previous payments to that same creditor?
I honestly can't answer that question based on my knowledge of the record. My understanding is that what happened here is originally Wachovia had loaned about $4 million to Portfolioscope, and there was a balance of that amount. KKP had guaranteed that loan, and it was in the context of that guarantee that KKP had taken its security interest. Sometime in 2001 or 2002, KKP took Wachovia out of the loan. They paid Wachovia the $4 million. They took over the balance. Over the course of the next few months and years, additional money was loaned to the company to keep it afloat as a business operation, and I believe also to fund the litigation. I don't believe there are any payments on that debt as it accumulated. It was when we got to the end and we got the iFlex settlement and the $10 million came in the door that the first payment was made to KKP on all this money that it had fronted Portfolioscope over the years.
Going back to UFTA, I mean, Section 5 says a transfer made by a debtor is fraudulent as to a creditor if the debtor made the transfer with actual intent to hinder, delay, or defraud any creditor of the debtor. Isn't that what the judge found here? That the transfer to Wheelahan was made for the purpose of delaying, hindering, or defrauding the plaintiff, who was a creditor.
And she found it based on three factors. One was the insider status of...
Well, that can be a factor.
Which can be a factor. The second was her finding that...
Well, the insider status, I mean, Wheelahan is the president of the company.
And KKP was controlled by Mr. Kimberlin.
Controlling
Yes.
the player in the company, so those are certainly...
That's one factor.
Okay.
Her second factor was a finding that that the transfers effectively rendered Portfolioscope insolvent. And that was simply incorrect. In fact, it's inconsistent with the finding that the judge herself made later in the opinion when she rejected the piercing the corporate veil claim. It's on page 25, where she finds there was no evidence that Portfolioscope was undercapitalized at its inception or that it was insolvent at the time of the challenged actions.
So if it was solvent, why didn't it just pay? It admits that it breached the contract. If it was solvent, why didn't it just pay?
It was solvent, but it wasn't liquid, and the reason that it wasn't liquid was $10 million came in the door. It was enough money to pay the $7 or $8 million that was owed to KKP. It was enough to pay the $400,000 that was owed to Mr. Weiler, but two events intervened. First, the lawyers, who had their statutory lien and they exercised it, took $1.8 million off the top, which was about $700,000 more than anybody at Portfolioscope expected them to do it. So there was money tied up there. The second event was there was another secured creditor, Mr. Hunt, who got a preliminary injunction that put $1.2 million into escrow pending the resolution of his dispute with Portfolioscope about how much money he was owed. Now, that money was still Portfolioscope's money. It was just an escrow. Nobody had taken it away from Portfolioscope and given it to Mr. Hunt. Nobody had made any finding about whom that money belonged to. So it was still Portfolioscope's money. It simply wasn't available at the time.
It wasn't held by Portfolioscope.
It was in an escrow account. I'm not sure whether that means it was held by Portfolioscope for the benefit of the eventual winner or not.
I thought the money had been transferred to Spencer Trask.
The money was transferred through a Spencer Trask account to this escrow
Well,
fund.
wasn't it, but didn't that 1.2 million, wasn't that a piece of what was transferred in theory as part of the paying off the secured debt?
No, that's on top of it. There was, let me see if I can do the math. $10 million came in, $1.8 million went to the lawyers, so now you're down to $8.2 million. Another $1.2 million went into the escrow account, now you're down to $7 million. $6.5 million went to KKP, $500,000 went to Mr.
But is that the way it really flowed?
Wheelahan.
I think Justice Bonsford's question is that the way it really flowed, or was, may have been a couple of checks, but was all 7.7 million turned over to Trask for the benefit of KKP, and then $1.2 million had to be escrowed? Which was the sequence here? Do you remember?
I'm not sure I can tell you how the judge made her findings, and by the way, it addresses another point that that Mr. Funder made about the notion that the money actually went to Spencer Trask and not to KKP. On pages 17 and 18 of her decision, the judge said that at the direction of Kimberlin, Wheelahan dispersed more than $7.7 million of the settlement proceeds to Spencer Trask, a company Kimberlin controlled. From there, the proceeds were directed to KKP LP, which Kimberlin also controlled. And then later on, in page 21, she says that the transfers at issue were to an insider of Portfolioscope, majority owner Spencer Trask, for the benefit of KKP LP. I'm not sure that completely answers the question about the additional $1.2 million. Logistically, the money did flow through the Spencer Trask account.
I don't have it in front of me, but there's she mentions the escrow ordered by Judge Gantz. Does it say there where that comes from, in that paragraph of her
Actually,
findings?
it looks like the escrow was ordered on November 14th, so, and the money was transferred to Spencer Trask when?
Very shortly thereafter.
So it was after that the money was transferred.
That's right. I mean, the money remember, the money came from iFlex, it went to the lawyers, so it was in an IALTA account or something like that. There had to be some account, some mechanism for the money to flow from the lawyers to this escrow account. It happened to be that it went into the same Spencer Trask account. Some of that money then was directed to KKP's benefit. Some of it went to Mr. Wheelahan, and the rest went into escrow.
Do you dispute that Mr. Kimberlin negotiated the October 2002 amendment?
I'm not in a position to dispute that right now based on what I know about the record.
Okay.
And why is it that you say this question about whether this is intra-corporate or not is a jurisdictional matter for Section 11?
Because the trade or commerce provision defines the scope of the statute, and it defines the authority that the courts have to issue remedies under the statute. I mean, think about it this way. If I was an employee and I had a dispute with my employer, and I went to court and I said, he's behaved unfairly to me, and he's been deceptive. He hasn't breached the contract, he hasn't committed fraud, but he's been unfair and deceptive, and I'd like punitive damages, and I'd like attorney's fees, and it's 1957, the judge is going to say to me, I can't help you. I don't have the authority to vindicate those rights. I don't have the authority to grant those remedies. If you take the same parties, the same dispute, the same behavior, and you fast forward it 40 years and you go back to, let's say, the same judge, he's going to look at the case and he's going to say, again, I can't help you. And you can hold up Chapter 93A and say, no, wait a minute, unfair and deceptive acts and practices are prohibited now, and you can give multiple damages for somebody who does that, and you can reward attorney's fees, and the judge will still say, but I can't give that to you because you don't meet the admission criteria.
Well, But why couldn't you also say, you don't meet the admission criteria because your employer has raised this, that it's not in trade or commerce as an affirmative defense? And if it doesn't raise it, guess what? It's waived.
Because it's something that, well, because it's something that gives you entree to the panoply of rights and remedies that are offered by the statute. Conversely, you could say,
But isn't that
this is
true
the
most
limits of the
affirmative
court's
defenses?
authority.
But if you meet the proof, the court has jurisdiction to give you your remedy. And that's the test of whether or not it's a jurisdictional issue versus whether or not it's a 12b-6 or a motion for directed verdict issue.
Well, it's who you are and where you did it. It's where you operated, not what you did.
No, but if you meet the proof, I mean, just to take this example, if, as Mr. Funder argues, that in fact, this is not an intra-corporate transaction. You got a whole bunch of players that are not connected. He meets that proof. He's entitled to recover. And I think what Justice Spina is saying is that if he can do that, then that suggests this is not a jurisdictional defect.
Well, I mean, respectfully, I disagree because I think all subject matter jurisdictional requirements are subject to proof. I've been involved in situations where people had to prove in federal court whether somebody was a citizen of this state or a domiciliary of that state. And so just the fact that it's something that's subject to proof doesn't mean that it's an element of the statute or an element of the remedy or an element of the right of action as opposed to a jurisdictional prerequisite.
Counsel, your time is up.
Thank you very much, Your Honor.
Yes, Counsel.
Yes. On that subject matter jurisdiction question, with the court's permission, I'd like to just quickly cite two cases which are in response to the reply brief of the defendant. So this is the first opportunity we've had to really pursue this. And one is the Doe versus Sex Offender Registry Board at 457 Mass 53, a 2010 case. And in that case, citing another key case, which is Middleborough versus Housing Appeals Commission, 449 Mass 514, a 2008 case, both of this court. These are not 93A cases, but they do discuss what is subject matter jurisdiction, which cannot be waived or forfeited, versus what is an element of a prima facie case or claim which can be waived if it's not raised until this court for the first time, for example. And the key question put in those cases by this court at the heart of subject matter jurisdiction is, has the legislature empowered the agency or court to hear cases of a certain genre? We submit that the legislature in Massachusetts clearly has authorized and empowered the Superior Court in Massachusetts to hear Chapter 93A cases, and that's what this is. And so by not raising this issue, they waived it. This only came up sua sponte in the appeals court. This whole 93A, the defendants have abandoned all their previous 93A arguments. I mean, we went round and round in the lower courts, both courts, and none of that is present in this court. This is the only 93A issue they have left, and it's only because the appeals court brought it up and ruled on it without any argument or briefing whatsoever on it. So this is the first time. But in addition to the...
No, Counsel? You'll have to wrap it up. Your 2 minutes are already up.
Oh, thank you, Your Honor, yes. If there are no questions, I'm finished. Thank you.
Thank you. We'll take our morning break. Thank you.
All right.